we all taken. Every step is guided by its own rules and law. So come, come, come to Tanlo. Come, come, come to Tanlo. Family law, employment law, and corporate law, commission of accounts, and all the other laws. Professional and friendly services we give you all. For all your immigration law, family law, employment law, business and corporate law, welfare benefits, charity law, will, commission of all litigation. Come to Town Law Solicitors or simply visit our website on www.townlaw.co.uk or simply call us on 024 776 32323. Town Law Solicitors, professional and friendly service.
Welcome today, our viewers. Today, I've got a special guest. My name is Andrew Nyamayaro. I'm the principal of Tanlo Solicitors, presenting today our usual weekly Wednesday updates on the law in the United Kingdom. Today, we are focusing more on business compliance from an accounting perspective, and we have got a guest who is a chartered accountant. Can you introduce yourself and say a bit about yourself, Simba?
Thank you, Mr. Nyamayaro. My name is Simba Madzima. I'm the director of Dan Accountancy Limited. I'm a chartered management accountant, and I also hold an MBA in finance.
Okay, Simba, nice to meet you. Can you then tell us how you assist businesses in the United Kingdom? I'm so much happy and excited that a lot of our kinmen of Zimbabwean origin or heritage have established themselves as businessmen and businesswomen in the United Kingdom. Some have got healthcare businesses, accountants like yourself, legal and different specialities. Some are operating under different auspices, is self-employed or under limited liability companies and so forth. So where do you chip in when someone establishes their business or is establishing their own business?
Okay. Firstly, perhaps just to share a little bit about myself, I do have quite some varied experience, which spans some various industries from logistics, supply chain, manufacturing, oil and gas, and I've also worked with the health sector. I've also worked with in the NHS and Lloyd's Pharmacy as an accountant, and as such, I have gained some quite a varied experience. Now, in terms of how we assist businesses, we assist businesses right from the start to register them. Maybe you want to register a new business. We can start with you from there, registering your company with the company's house, and then work with you until you submit your first year accounts. So we provide services for completing statutory accounts, which are filed with the company's house, and then corporation tax returns, which are filed with HMRC. Well, these are things which are done by law. So the law expects that every registered business should submit statutory accounts, and they should also submit their tax returns. So we will help you with that, and then we also help businesses with bookkeeping, because by law, every company is expected to keep their records of financial transactions. So we offer bookkeeping services. However, if one does not wish an outsider to do it, but they want to do it themselves, perhaps they don't know how to do it, we are also happy to assist until they get to know what they need to do. Other services that we help businesses with include running payroll, producing pay slips, calculating the NIs, the payees, and auto enrollment, dealing with such issues so that your employees are well serviced, they receive their pay on time. And then additionally, other than doing the compliance work, we also offer some planning, strategy, meetings with business leaders. So perhaps you've grown your business, everything else is okay, your compliance is all right, but maybe you need some help in getting to the next step, but you don't know how to get there. Then we are here to help. We sit with you and then discuss your ambitions and then help you to achieve them. So maybe you want to have £1 million or 10 million pounds, but you don't know how to get there, but you have the idea of what to do to generate it, but you don't know how to get there. We are able to sit with you and then chop it down into manageable sizes of steps, which you can actually look back and really forecast and be able to determine your progress.
Okay. And if I am a new startup, what factors do I have to consider whether to become self-employed or a limited liability company, and maybe even an LLP or any other vehicle that I can use to get into business? What can I consider from a financial perspective?
Okay. If you're a startup, you can choose to be self-employed, or you can choose to be a limited company. So what the key differences between those two is that a limited company it's limited in terms of liability. So the liability is limited to the company, whereas self-employed, the liability rests with you. So from a financial perspective, it is more financially viable to be a business, to be a limited company, than to be self-employed. So normally when you are self-employed, so you are self-employed. Whereas if you are running a limited company, the expectation is that you are utilizing more labor to generate more revenues and profits, and there are certain financial advantages in line with that. Specifically, we'll be happy to attend to specific questions where we can actually help.
Okay. You keep speaking about the law and compliance. What are the implications? Let's start with the company's house. What are the implications if someone doesn't comply? Sometimes you go in the company's house, you see some businesses, they've put outstanding submissions that have not been submitted, or incorrect information, or information has not been updated. Is there any legal implications?
Absolutely, absolutely. Yes, if you do not submit your returns on time, you will face some penalties. And sometimes you can have your company struck off. So for instance, every company is supposed to submit a confirmation statement annually. So if you do not submit your confirmation statement, they give you 2 months where they'll then gazette to say this company is up for striking off. So it will be gazetted for 2 months. So within those 2 months, if you do not respond, your company will be struck off. While you can restore it, it is a very lengthy process, which is very costly, both in terms of money and in terms of time. This is just the confirmation statement. So if you do not file your accounts, your statutory accounts on time, then you will face penalties. Now, the penalties increase each time you miss. So say, for instance, you miss your first year accounts, then you face a penalty maybe about 175. And then if you miss in consecutive, the next time they'll charge you 350. If you miss again, it goes up to 750. If you miss again, maybe 1,500 up to about 3,000. And it is what it is. So if you do miss, they will give you a penalty. Even if you try to appeal, in most cases, they do not accept appeals in that regard, because they say you knew well ahead that you had to file and you had all this much time and you did not. So it is important to comply in terms of that for the Companies House. And then equally for HMRC, if you do not make your submissions for corporation tax in time, they'll also raise penalties as well.
Okay. Sometimes we've come across situations whereby whether people they are self-employed or in business, people tend to present not correct accounts, not reflecting the correct position, but tailor-made to suit a particular situation. And sometimes if a company doesn't want to pay a lot of tax, corporate tax or pay or whatever, they cook the books, so to put it that way, or maybe someone who's self-employed as a live-in care or whatever, they underdeclare their income. What is the repercussions in terms of maybe say their credit scoring or once they are discovered and issues like that?
Okay, so what happens is if one gives false information, it may be caught straight away, but even if it's not caught straight away, down the line they will catch you out, and when they catch you out, they will go back for a period of time just to check to see if you complied before, and then whatever amounts that you were due to pay, they'll still ask you to pay it. I mean HMRC. So HMRC will still ask you to pay whatever you missed, even if it's from past periods, 3 years, 5 years, 7 years, they can still ask you to pay whatever you missed. And then on top of that, they'll add a penalty. So it is always good to do it right in the first place. And then sometimes it can be treated like fraud if, for example, if you present figures which results in you getting some tax refunds, that can also be treated as fraud.
Okay, that's an interesting point, because I think it can also touch on the issue of people who receive benefits. And in this country, there's a term which they normally use, benefit cheats, where people claim what they are not supposed to be claiming or overclaim, or go to where they are not supposed to be going in terms of DWP. Do you deal with such situations, and any examples that you can give?
The Examples which I can give is around people who use umbrella services which are dubious. So whereby one goes to work, maybe they work for an agency, and then the agency sends the money to an umbrella company. And then the umbrella company pays you money in what they call efficient way, but it will not be efficient, it will be fraudulent. So what they do is they give you two payments. So you work one where you're expecting to get one lump sum, they'll give you two payments for that period. So what happens is the first payment is a small amount which has got very little or no tax. And then they give you another payment which is bigger, but then they give you that as maybe a bonus or a loan. So no one would ordinarily ask to tax for a loan. So what happens in time, when the umbrella company goes bust, they'll get to know every single person who dealt with that umbrella company. Then they go after each and every one of those individuals. So when they come to you, they'll say, okay, you received a loan from this umbrella company over a period of so many years, so you owe us that money. Naturally, because to you it's not a loan, it's money that you worked for, you're gonna say, no, I never got a loan, it was my money which I worked. And then they'll say, okay, let's retally all the money that you received from a perspective of the agency where the funds originated from, and then they do calculate the tax that you were initially supposed to pay. So now this can go back as far as I know of a case which has gone back 7 years. So the amount could be very enormous, maybe 70, 80,000. You can end up owing that in tax. Usually it happens for people who earn higher rates, but not saying those who earn little do not face the same consequences. They will still face the same consequences. So they will ask you to pay that back plus a penalty.
Okay, thank you. Having mentioned about umbrella companies, I'm aware that some people have been using umbrella companies since the introduction of the IR35. So maybe if you can comment a bit on IR35, what it is and the implications, and how it can be dealt with.
Okay. So what the government has done is they're trying to find efficient ways of collecting tax. As you know, the government is funded from tax. So what they have discovered is that there were a good number of people who were using personal service companies. So these are like one-man band company. So it appears as though it's a company, but actually in terms of their execution of duties, there will be an employee, in the sense that they've no decision making. They have to go just like the employee. They cannot choose when and when not to go. They cannot substitute their services to say, okay, instead of me coming, I'm sending so and so, which things which ordinarily a company would do. So if, for example, I was to engage your firm, in my case, I don't decide which solicitor is going to come or which consultant will come. All I know is I've presented my case to you. You decide whoever will come and sort out my case. If we were looking at an example of the relationship between a solicitor's firm and any other firm. Same like if a nursing home requests for carers or nurses from an agency, all they do is they put in an order to say we want 10 people or we want 5 people. They don't choose who comes, and then the agency will just send whoever is in their books, right? But the personal service companies, they don't have that ability. So on one end, while they appear as though they are companies, in real terms, they are employees. So what the government has done is such companies, they either have to go on payee, so wherever they are working, they join the payroll of that company and have their funds taxed there at source. If not, then they have to choose an umbrella company which is associated perhaps or which is acceptable to the employer. Then that umbrella company will be responsible to run the payroll, deduct the payee, employee NI, and then it also deducts employer's NI. And if this person is also enrolled on pension, they also deduct employee pension and employer pension. Thank
And
you.
what are the consequences of not complying with that?
Right, so not complying with that definitely will come with penalties. Now, depending on what it is that has been breached and what stage, the scale varies depending on the breach that will have been conducted. But for a more closer look into the case, if anyone would like to get in touch with us, then we'll be in a position to explain based on a case-by-case basis.
Okay. Moving on, what help is Dan Accountants giving to its clients with regard to the help that government is giving to businesses? Where are you involved in relation to COVID-19?
Okay, Dan Accountancy has been trying to alert all customers, whether our own customers or businesses at large, through various forums. We have brought awareness of the support that the government is giving. For example, employers who are facing some issues with their wage bills, we have advised people, and we continue to do so even on this forum now. The government is offering the fellow grant. So if you have got some problems with your wages and you cannot afford to pay your employees due to corona virus challenges, then you can fellow your employees, and then the government will give you, at least up to this month, they are paying 80% of the normal person's salary, and then the company only has to pay the employer NI. So this continues to run until September. However, the rates will change as from July, August, September, they will be varying. For precise figures, feel free to contact us, then we can address your specific case. And then for clients who are in healthcare sector, I know there is the infection control grant, which is still running. I hear the money hasn't been finished. So if you are in the healthcare sector, it is important that you contact your local authority. They are distributing some monies. I'm sure there should still be some, which is still available. So those are some of the grants. So these are free monies which are being given by the government to assist businesses.
Okay. My last question to you before I excuse you, sir, is the one in relation to the sponsor license. We know that the government, or rather many people are applying for a sponsor license to bring employees from outside the United Kingdom. And the government requires a lot of documents, some financial, legal, bank statements and things like that. So where in this situation does done accountants fit in?
Thank you. So what happens is some of the requirements, there are obviously requirements which the government has stated that they would want in order for one to support their application. So where done accountancy comes in is to tidy up your books so that you have your accounts which the government would like to see. So we'll be able to help you with that. And then also in the just assembling of whatever documents from a financial perspective which will be required. And then some of the requirements, be it at the first stage or at the second stage of the application, at some point they may also ask you about your plan, your business plan, and maybe your organizational structures, organogram, etc., etc. We help you to structure this in a meticulous way so that it portrays exactly who you are, what you think.
Okay, thank you so much, Simba, for being on this program today. If you can just give us again your contact details. I know that they're on the screen, but if you can just shout them out or where people can get you, your terms of operation, and then I can excuse you, and then I can go into the next bit of immigration. For immigration, I'm taking questions and answers. So if you've got any immigration questions, you can put them in the chat, and then I'll be able to respond as much as possible. It can be what we're talking about, the sponsor license, or anything else in relation to immigration. So Simba, if you can just give us your contact details.
Okay, thank you very much, Andrew, for inviting me. We are Dan Accountancy. We are available in Coventry at number 105 to 107 New Union Street, CV 12NT. Otherwise, our website address is www.danaccountancy.co.uk. So DAN and the word accountancy.co.uk. Otherwise, you can also reach us on telephone 024 7767 3029 or a mobile 079 12 793 792. Thank you.
Thank you,
we are also available on Facebook at Dan Accountancy. Follow us and do make an appointment. Reach us even for free consultation. We are happy to chat with you for the issues discussed tonight or any other issues. Don't hesitate. We will offer you free consultation. Thank you.
Thank you, Simba. It goes without saying that you can take remote consultations as well. People don't really need to come to the office. They can come, subject to COVID-19 precautions, but you can also
Yes,
take
sure.
instructions over the phone or virtually.
Indeed, indeed. Remote will be fine. Telephone calls, emails, that will be excellent. Thank you.
Thank you, Simba.
Okay.
So we are now moving on to immigration. And on immigration, I'm just taking questions, and then I'll be able to respond as much as possible. So if you've got any immigration issues in relation to the United Kingdom immigration matters, I can be able to answer your questions. If not, I can respond at a later time through email or on the phone. But by way of updates, the 30th of June is the deadline for people to submit their applications under the European Union Settlement Scheme. The European Settlement Scheme was started by the government because the United Kingdom has left the EU, and it's now a standalone country. It's no longer part of the EU. But however, during the last 6 months, which was more like a grace period, the government has been accepting applications from EU citizens and their family members so that they can be able to change their papers from the old status that they had as EU citizens. So you have either the pre-settled status or you've got the settled status. If you have been in the United Kingdom for more than 5 years and there's a trackable record on whether you were employed, self-sufficient, a student, or you are a business person, then you can be able to apply for the settled status. Normally, the most important will be submitting your NI number and a few of the documents that may be requested. If you were in the United Kingdom for less than 5 years, then you can be granted for the pre-settled status. We have been doing a number of such EU applications, as you would know, because people are now rushing because of the deadline that is coming up. So it is important for people to make their applications before the deadline of the 30th of June. The government is saying that you can submit your application maybe after the 30th of June, but you have to show reason why you did not submit the application before the deadline. There are some other exceptions that are available, like maybe the Surinder Singh route, whereby people can still make their applications up until March 2022. But to be on the safe side, it is important for people to make their applications by the deadline, which is next week. So EUSS applications deadline is next week. It's a free application. You don't pay anything. It's done online. But however, Tan Law Solicitors has got expertise in dealing with these applications. So if you want help with these applications, you can contact us and we'll be able to help you. Again, in line with the EU law or the EU regulations, which have now been moved into the immigration rules as an appendix, there is a case that was recently decided by the courts. It's a case which is in line with Zambrano. So in that case, the appellant or the applicant was a lady from Nigeria who came to the United Kingdom. And while she was in the United Kingdom, she got a leave to remain as a primary carer of a British citizen, which we commonly call the Zambrano route or the Zambrano rule. And because she was on that route for a while, she on that route, she became ill and she could not have recourse to public funds, and she was advised to switch from the Zambrano to discretionary leave to remain because she was a carer of a British citizen, which she did. When she got the news of the EUSS, which I was talking about, she then wanted to switch back to Zambrano, where she could be considered as a primary care of a British citizen. And the Home Office refused the application, stating that, citing the appendix in the immigration rules, that where a person has got an alternative route to apply for leave to remain, then they cannot rely on derivative rights under the Zambrano route. That was challenged in court, and the court said that she can still proceed to apply for a derivative permit under the Zambrano route. I'm aware of quite a number of people that were rejected or refused their applications before the Home Office, citing that appendix, that they've got an alternative route to apply as a family member of British citizen. So if you want your case to be reconsidered by the Home Office, you can contact us so that we can ask the Home Office to reconsider your application, or you can make a fresh application to the Home Office on the basis that Zambrano applies to yourself, even if it was refused before. And you can do the Home Office can do, under the circumstances, a reconsideration of your case. So that is under the Zambrano or the derivative rights, which someone can also make an application. However, it still remains that if you have a child in the United Kingdom who has spent 7 years or more, or was born in the United Kingdom and they spent 10 years or so, you can still make an application on the basis of your children for leave to remain, and you will be granted a discretionary leave to remain by the Home Office. If your child was born in the United Kingdom and they spent 10 years, even if they didn't have any leave to remain, they qualify to be British citizens, and we have to make an application to register them as British citizens. So they have to make a naturalization application. Again, if you require our services, we should be able to help you to register your child as a British citizen. In that case, we just need to prove that the child was born in the United Kingdom, has spent the past 10 years in the United Kingdom. We will produce things like school reports, the birth certificate, the birth record book, photographs, letters of support, documents from the GP or the dentist, or people in positions of authority in the life of that particular child or children. So you can make that application. There is a fee that is applicable. The courts some time ago ruled that it is unlawful for the Home Office to charge a fee where children are being naturalized as British citizens. The Home Office have not yet changed their stance on that. They are still charging a fee. The fee is around £1,000 that you pay to register your child as a British citizen in the United Kingdom. Carrying on the issue of immigration, if you are an adult and you want to apply for British nationality, the fee is again, off my head, about £1,389, and you need to be a person of good character. That is an important requirement in the sense that some people who have illegally lived in the country within the last 10 years might not make successful applications to naturalize as British citizens. So where you've been in the United Kingdom for 10 or so years, then you should have a clean immigration history for the past 10 years so that your application for naturalization should be successful. Otherwise, the Home Office will refuse the application on the basis of good character. Again, if you are making an application for naturalization, you should have passed your English test, and you should have passed, unless if you are from a country that has got a majority speaking English country, considered like that by the Home Office, and you should have passed the life in the UK citizenship test. And then you have to produce the evidence. I think about 6 documents per year that you need to produce for the past 5 years or so. You should have been in the country in the last 12 months for about 9 months in the last 12 months. So you should not have been in the country for more than 90 days. And again, they also calculate your period of absence in the past 5 years. I think it should not be in excess of 540. It should not be in excess of 540 days that you would have been out of the country. In terms of our contact details, we are available online. We've got our website www.tanlaw.co.uk, and our contact numbers. The office number is 024. Let me just put it in the chat: 632323. That's the office number, or WhatsApp 0742142938 will be the mobile number if you desire to get in touch with us. Where again you are making an application, say for yourself or for the children, for a limited leave to remain application, and you are struggling financially, then you can make an application for a fee waiver. Of late, during the past months, because maybe of COVID, the Home Office has been understanding. A number of applications for fee waivers have been successful, but the Home Office would want to know about your income and your expenses. So they'll ask for your financial information. If you have got a bank account or bank accounts, you need to disclose all the bank accounts. Otherwise, if you don't, they will go on credit scoring companies such as Experian, and then they can check and then they can be able to see the information. So you just need to be upfront with your information and give the reasons why you cannot afford the fees. Whether you are destitute or paying the fees is likely to leave you being destitute. So there is that help again that is available for you if you cannot afford the fees for applying for a limited leave to remain visa. One thing that I want to comment on before I conclude is at the time of submitting your application, especially when you've got a visa already. You need to submit your visa within the last 28 days of your visa expiring. So anytime within the last 28 days, you can make an application to extend your visa. You cannot submit it earlier than that because it will be considered to be invalid. And if you miss to submit it by the date your visa expires, you have got 14 days within the date of your visa expiring to submit information or rather a new application. Otherwise, after 14 days, then you would have broken with the continuity of your visa. So you would have to restart the period again. So it is important to know when your visa is going to expire. It is important to know the validity period of your visa. If it's in terms of making an appeal, for let's assume that your Home Office application has been rejected and you have got the right of appeal. If you are within the country, you've got 14 days, that is 14 calendar days for you to submit your application or rather your appeal to the first tier tribunal. And if you are outside the country, you have got 28 days to submit your appeal to the first tier tribunal. If the first tier tribunal is dismissed your application and you want to make an application for permission to appeal to the upper tribunal, that can be done on the basis that the judge has made an error of law. It's a technical term which you will require, in most cases, someone with the expertise to go through the decision that has been made and pick up the error of law that the judge has made, and then you make an application for permission to appeal initially in the first tier tribunal, and after that in the upper tribunal if the first tier one is rejected or dismissed. So you've got 14 days either way to make your application for permission in the first tier tribunal. If it is dismissed, again another 14 days if you are within the country. If you are outside the country, then you have got 28 days. In certain circumstances where your visa application has been rejected, especially for people who have got who are making what we call fresh claims or further submissions, the Home Office might not give you a right of appeal. That means that you have to consider what is called the judicial review. Sometimes they might have certified your case as clearly unfounded if they think, for example, that it's just now an argumentative application that you are putting in, or it's just a baseless application that you are putting in. The circumstances have not changed from the last application that you submitted before. In that case, then they might just refuse it without a right of appeal. But if you do believe that your case is strong enough, you can make an application for judicial review. The process is that you have got 3 months from the date of the decision up to the date that you can submit your application for permission in the court for judicial review. But however, in the intervening period, you are supposed to submit to the Home Office what is called a pre-action protocol. In that pre-action protocol, you are giving the reasons why you believe that maybe the decision of the Home Office is unlawful, it is irrational, the unfairness of it, and so forth. So much that you are, in other words, asking the Home Office to reconsider their decision so that they can overturn their own decision, or at least grant you a right of appeal. So in that case, you normally give them about 14 days to respond. Sometimes the Home Office responds, sometimes they don't respond, but always bear in mind that you've got 3 months to then submit your application to the court, and then you can then submit your application to the court. The first round, the court will consider the application on papers. You don't do any oral submissions. If it is dismissed at that stage, you can then maybe make an application for an oral hearing in the upper tribunal, mostly to be in the upper tribunal, and then the process goes on like that. So it is quite important to bear the time limits within which you have to submit your applications or your appeals or the judicial review, because if you don't, you lose your right to that. And while it may be you might pray for an extension of time, it is an onerous task, and the court or the Home Office may refuse to do that, thereby affecting your visa or your leave to remain. Someone is saying that they had a DL10 in 2014. Will it affect the citizen application? So where someone has had an offense, or even where someone you have been declared bankrupt, or you have gone into an IVA, you've got a conviction of more than 12 months, or even a conviction of less than 12 months, but they have got several convictions, the Home Office might not consider that person as a person of good character, and that might affect an application for citizenship or naturalization. However, it is up to you to make submissions to the Home Office to convince them that you are a person of good character, you have reformed and rehabilitated, and you are no longer a trouble causer, or you are now a good person, you're now paying your bills and everything like that. So it is, while it can impact on your application, you can also make submissions so that the Home Office might consider your circumstances. If you require any assistance in terms of immigration, employment, family, civil litigation, TAN law solicitors can help you. We are also commissioners of oath, and we also draft wills. So for this week, I do not have any further questions, and I thank you all for listening to my guest and listening to me, and we will be meeting again next week. Thank you.